Cybercrime Prevention Act of 2012, RA 10175. The following constitute cybercrime offenses. 1. Offenses against the confidentiality, integrity, and availability of computer data and systems. 2. Computer-related offenses. 3. Content-related offenses, cyber libel, cyber sex, and cyber child pornography. A prosecution for cyber crime offenses shall be without prejudice to any liability for violation of any provision of the revised penal code or special laws. Section 7. Despite Section 7, the offender cannot be prosecuted for cyber child pornography under RA 10175 in addition to child pornography under RA 9775, since this will offend the constitutional rule on double jeopardy. Diceny versus Secretary of Justice, February 11, 2014. Offenses against the confidentiality, integrity, and availability of computer data and system. Offenses against the confidentiality, integrity, and availability of computer data and systems are cyber crimes under Section 4 of RA 10175. Computer data refers to any presentation or representation of facts, information, or concepts in a form suitable for processing in a computer system, including a program suitable to cause a computer system to perform a function, and includes electronic documents and/or electronic data messages, whether stored in local computer systems or online. Computer system refers to any device or group of interconnected or related devices, one or more of which, pursuant to a program, performs automated processing of data. It covers any type of device with data processing capabilities, including but not limited to computers and mobile phones. The device consisting of hardware and software may include input, output, and storage components, which may stand alone or be connected in a network or other similar devices. It also includes computer data storage devices or media. Offenses against the confidentiality, integrity, and availability of computer data and systems are: 1. Illegal access. Illegal access is committed by any person who shall access the whole or any part of a computer system without right. Ethical hackers are professionals who employ tools and techniques used by criminal hackers, but would neither damage the target systems nor steal information. Since the ethical hacker does his job with prior permission from the client, such permission would insulate him from the coverage cybercrime law on illegal access. Diceny versus Secretary of Justice. X was able to get hold of the Facebook password and, without authority from A, accessed his personal message containing photos of A and B using dangerous drugs in Amsterdam and shared these photos on Facebook. X is liable for the cybercrime of illegal access, 2018. One who hacks his neighbor's internet access by cracking his Wi-Fi password is liable for cybercrime of illegal access. Internet connection is part of the computer system, accessing of which without a right is punishable under RA 10175. Moreover, the hacker can be held liable for theft. In the case of Laurel versus Abrogar, January 13, 2009, personal property, the taking of which is an element of theft, includes intangible property. As early as 1910, the Supreme Court declared in U.S. versus Genado that ownership over electricity, which an international long-distance call consists of, as well as telephone service, is protected by the provision of theft of the Penal Code. Thus, accessing wireless internet connection without consent of the person to whom it belongs constitute unlawful taking. The hacker can also be held liable for the crime of access device fraud under RA 8484, but RA 10515, which punishes interception of cable internet system, is not applicable since a Wi-Fi internet connection is a cableless internet system. According to Palmer Maliari, a cybercrime expert, in 2013, when RA 10515 was enacted, the use of wireless internet system was not yet widespread in the Philippines. Hence, interception of wireless internet system was not included in the law. Number 2. Illegal interception. Illegal interception is committed by any person who shall intercept by technical means without right of any non-public transmission of computer data to, from, or within a computer system, including electromagnetic emissions from a computer system carrying such computer data. Computer hacking constitutes illegal access or illegal interception. Tapping the telephone wire to intercept the landline telephone communication between two parties without consent of both of them constitutes violation of the anti-wiretapping law. Intercepting the wireless cell phone communication between parties without a right constitutes cybercrime of illegal interception. Number 3. Data interference. Data interference is committed by any person who shall intentionally or recklessly hinder or interfere with the functioning of a computer or computer network by impeding, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or program, electronic document, or electronic data message without right or authority, including the introduction or transmission of viruses. In May 2000, a Filipino computer wizard unleashed the most prevalent and costly computer virus known as Lovebug. This mass-mailed "I love you" worm affected nearly 45 million computer users worldwide. This entailed as much as US $15 billion to repair the damage. There is no qualm that the act of spreading computer virus is wrongful in character. However, the culprit was not prosecuted for a crime since there was no law in the Philippines in 2000 punishing cybercrime. Nullum crimen nulla pene sine lege. At present, transmission of computer virus that interferes with computer data or system constitutes cybercrime punishable under Section 4 of RA 10175. Number 5. Misuse of devices. Misuse of device is committed by any person who shall use, produce, sell, procure, import, distribute, or otherwise makes available, or possession with intent to use, without right to any of the following. 1. Device, including a computer program designed or adopted primarily for the purpose of committing any cybercrime. Or 2. A computer password, access code, or similar data by which the whole or any part of a computer system is capable of being accessed to it intent that it be used for the purpose of committing any cybercrime. Number 6. Cyber squatting. Cyber squatting is committed by any person who shall acquire a domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same. If such a domain name is a similar, identical, or confusingly similar to an existing trademark registered with the appropriate government agency at the time of the domain name registration. B. Identical or in any way similar with the name of a person other than the registrant in case of a personal name. And C. Acquired without right or with intellectual property interests in it. Squatting is the act of occupying an unoccupied land or building without consent of the owner. On the other hand, cyber squatting is the act of registering an unregistered internet domain name in bad faith to profit, mislead, destroy reputation, and deprive a person to whom the domain name belongs from registering the same. For example, Rex Bookstore Publishing Corporation is entitled to the internet domain name www.rexpublishing.com.ph. However, it failed to register the name. Rika Publishing Company registered the domain name www.rexpublishing.com.ph and used the website with such name to sell its book online. The registration is made in bad faith since the public is being made to believe that the registrant of the website with such name is selling books published by Rex Bookstore. With the registration of this domain name, Rex Bookstore cannot anymore register such domain name. Thus, the responsible officer of RICA Publishing are liable for cyber squatting. Computer-related offense. The following are computer-related offenses. 1. Computer-related forgery. Computer-related forgery is committed by any person who shall input, alter, or delete any computer data without right resulting in an authentic data with the intent that it be considered or acted upon by legal purposes as if it were authentic, regardless whether or not the data is directly readable and intelligible, or who shall knowingly use computer data, which is the product of computer-related forgery, for the purpose of perpetrating a fraudulent or dishonest design. Number 2. Computer-related fraud. Computer-related fraud is committed by any person who, without authority, shall input, alter, or delete computer data, or program, or interfere in the functioning of a computer system with fraudulent intent causing damage thereby. The penalty is lower if no damage has yet been caused. Number 3. Computer-related identity theft. Computer-related identity theft is committed by any person who shall intentionally acquire, use, misuse, transfer, possess, alter, or delete identifying information belonging to another, whether natural or juridical, without right. The penalty is lower if no damage has yet been caused. Using the name of another person and his pictures in opening a Facebook account without authority constitutes cybercrime of identity theft. Spam. Unsolicited commercial communications is committed by any person who shall transmit commercial electronic communication with the use of computer system which seeks to advertise, sell, or offer for sale products and services. Transmission of unsolicited commercial communications is also known as spam. In this unique case, the provision of RA 10175 prohibiting spam is declared unconstitutional. It was held that to prohibit the transmission of unsolicited ads would deny a person the right to read his emails, even unsolicited commercial ads addressed to him. The state cannot rob him of his right without violating the constitutionally guaranteed freedom of expression. Unsolicited advertisements are legitimate forms of expression. Other cybercrime offenses. Other cybercrime offense is also committed by any person who shall willfully abet or aid in the commission of any of these cybercrime offenses, or any person who willfully attempts to commit any of the cybercrime offenses. Section 5. The provision on aiding or abetting cybercrime in relation to cyber libel, child pornography, and unsolicited commercial communication was declared unconstitutional in the Dicini case. The terms aiding or abetting constitute broad sweep that generates chilling effect on those who express themselves through cyberspace posts, comments, and other messages. Hence, this provision that punishes aiding or abetting libel on the cyberspace is a nullity since it encroaches upon freedom of speech on grounds of overbreadth or vagueness of the statute. A blogger who originally posted a libelous or child pornographic message is liable for a cybercrime. But netizens who merely reacted to the defamatory or child pornographic message on Facebook by clicking the button for like, comment, or share, or on a Twitter account by retweeting it, are not liable for aiding or abetting cybercrime. But the provision on aiding or abetting cybercrime in relation to other cybercrimes, such as illegal access, illegal interception, data interference, etc., is declared constitutional. Prescription for cybercrime. Under Act No. 3326, the prescription period for a crime under special law punished by imprisonment of 6 years or more is 12 years. Most of the penalties under Section 8 of RA 10175 prescribed for cybercrimes such as cybersex, defined under Section 4 thereof, are imprisonment of more than 6 years. Hence, as a general rule, the prescriptive period for cybercrime under RA 10175 is 12 years. One of the cybercrimes defined under Section 4 of RA 10175 is cyber libel. Section 8 of RA 10175 prescribes penalties for all cybercrimes under Section 4, except cyber libel. It seems that through oversight, Congress failed to provide a penalty for cyber libel. Hence, an offender who committed libel through the Internet cannot be prosecuted for cyber libel under Section 4 of RA 10175, simply because there is no penalty under Section 8 for committing it. However, libel through the Internet is still punishable under Article 355 of the Revised Penal Code. Section 6 of RA 10175, using information or communication technology in committing a crime, will upgrade the penalty for it by 1 degree. In sum, one who committed libel through the Internet shall be prosecuted for libel under the Revised Penal Code with the qualifying circumstance under RA 10175. He cannot be prosecuted for libel under Section 6 of RA 10175, since this provision does not define a crime but merely provides a modifying circumstance that will adjust the penalty for a crime punishable under the Revised Penal Code. Since an offender is committing Internet libel, can only be prosecuted for libel through the Internet under the Revised Penal Code, Article 90 of the Code on Prescription applies. Under this provision, the crime of libel shall prescribe in 1 year.